With 2023 coming to a close, it's time to do an overview of CRPA's litigation for the year. Hey everybody, welcome back to the channel today. It's the end of the year and I hope that you are celebrating appropriately. There is certainly a lot to celebrate about. And while we are encroaching on 2024, I did want to do a video of just kind of an all-encompassing what happened with CRPA litigation throughout the year. So here we are, and you're going to have to forgive me with my voice today. I'm a little bit under the weather, but to do this, we have brought on CRPA's volunteer president, Chuck Michelle. Chuck, thank you very much for being here with us today.
Thanks for having me, guys. It's always a pleasure.
Absolutely. So why not just go ahead and start with the oldest, active, well, I don't want to say oldest active lawsuits, but certainly some prominent ones that happened in 2016 because of Prop 63. I'm talking about Duncan v. Bonta and Rhode v. Bonta. We had some promise for these cases coming out of Bruin. So if you can, go ahead and just give us a brief definition of what these lawsuits are and what happened with them in 2023.
Sure. Well, the Duncan v. Bonta lawsuit is a challenge to the ban on possession of magazines that can hold over 10 rounds. That began as a law that grandfathered in people who previously possessed those, and then it was expanded by Prop 63 to completely ban the possession. We immediately challenged that and won in front of Judge Benitez down in San Diego first time around. That was, I want to say, like 5 years ago. That had a very long appellate process, actually wound up in front of the United States Supreme Court. The Supreme Court said that what the en banc panel in the Ninth Circuit had done was wrong, sent it back down. It made its way all the way back down to Judge Benitez again to now reconsider his previous ruling in light that he had issued under Heller and reconsider that in light of Bruin and see if it still reaches the same conclusion. Well, of course he did. Actually a stronger conclusion. He issued a 174-page opinion about why the ban on the possession of magazines is a violation of the Second Amendment. That's now in the Ninth Circuit in front of an en banc panel, the en banc panel that we were in front of before again. And we are briefing that and also looking at options to go directly to the Supreme Court because the en banc panel is playing some games, kind of stacking the panel against us. Although we won, we lost 7-4 last time under Heller, and so we really only have to pick up 2 votes, which it's possible to do under Bruin. It's much harder for a judge to twist Bruin than it was to twist Heller. So we're hopeful that the en banc panel will see it our way. If not, we will be in the Supreme Court on that one.
And what about Rhode v. Bonta? That was another one. I mean, these cases are kind of happening at the same time. They both came out of Prop 63. What about the ammo regulations?
Okay, the Rhode v. Bonta case is our main plaintiff is Kim Rhode, the Olympic sporting clays shooter who we should all know of and all love for her support for the Second Amendment and her excellence at the shooting sports. That challenges the ammunition background check, which has resulted in about 15% of the people ultimately not being able to buy ammo. And that's what all this is really about. It's trying to red tape the right to death so that people give up on it. We won in front of Benitez again several years ago. It went up to the Ninth Circuit. It was stayed there while the Duncan decision was sitting in front of the Supreme Court. When that came back down from the Supreme Court, they didn't decide it. They held it until after Bruin. They issued Bruin, and then they just vacated the lower court Duncan decision. And then all the cases that were backed up, bottlenecked behind Duncan, were released from their stay. Rhode was sent back down to Judge Benitez again in light of Bruin to reconsider his ruling under Heller. Now to reconsider it under Bruin. He is still in the process of doing that. We just submitted our last brief in front of Judge Benitez a week ago. We expected a decision out of him any day now. He's actually moving these cases a lot faster than he was a while ago. So we expect we'll see something on that pretty quick. The state will no doubt appeal it up to the Ninth Circuit again, and we will have to go through that But in the meantime, it's a win, and we unfortunately none of these cases have well, the Duncan case is partially enjoined. If you possess a magazine, you can keep it, but you can't buy new ones. The Rhode decision, we will fight an injunction and try and get that ammo background check requirement taken off because so many people are having so much trouble getting ammunition. So that'll be another fight we'll have to have. But ultimately, it'll be in front of the Ninth Circuit, and we will see what happens there. And again, it could go to the Supreme Court. And we have Rahimi pending in the Supreme Court, which may set some things straight that would help us in Rhode, Duncan, and all the other cases that we have.
So the right to manufacture, import, and purchase magazines, the right to purchase ammunition. What about where we can purchase these things? We saw, I personally, along with others, had been fighting in fair boards for a few years as we saw a huge push to get rid of gun shows. Last year and the year prior, we finally started seeing legislation come out of Sacramento to essentially ban gun shows on state-owned property. If you didn't know, a lot of gun shows happen on fairgrounds, which is state-owned property. So there have been a few lawsuits filed on this one, but we did get some action on B&L Productions v. Newsom. Can you explain that one a little bit?
Yeah, there were two cases there. Both are now in the Ninth Circuit again. We won one. That was a great win. And those challenges are based on First and Second Amendment constitutional law. The other case, the judge was not particularly receptive and granted the state's motion to dismiss before we even put any evidence on. So there's sort of a split there that we have to reckon with in the Ninth Circuit. But the three-judge panel that gave us, or excuse me, the district court that gave us the win on First and Second Amendment grounds, that was very well reasoned. There's another lengthy opinion. The state, makes all these false claims about crimes taking place at gun shows. I mean, anytime you have tens of thousands of people assembled, there's going to be fights. There's going to be people who get drunk. It's not specific or something that happens because it's a gun show. It's just because there's a lot of people together. But there's nothing relating to gun crime that happens at a gun show. It's one of the most heavily policed activities where guns are sold in the state. The court called them out on called the state out on all the baloney that it was trying to get away with, and now that's in front of the Ninth Circuit. So those two cases are both pending there, and they may be consolidated or coordinated in front of one panel. We'll see, or it may be two. But those are in the Ninth Circuit, and in the meantime, the injunction is in place against that law, so that B&L Crossroads of the West has got contract dates for several gun shows in several venues throughout the state. So unless something changes, and I don't think it's going to, we're going to have gun shows even while this case goes through the Ninth Circuit.
Well, I do know that Crossroads, at least in Costa Mesa, has a gun show that is scheduled on the 19th of January. So that's certainly some progress there. We are winning on these cases, and it's starting to show, which is a good thing. One of the arguments that we made in that B&L Productions v. Bonta or Newsom lawsuit was the freedom of speech aspect. We've got another lawsuit on freedom of speech. This is Junior Sport Magazine v. Bonta, which is a consequence of AB 2571 last year. This was the one where Newsom came out on TV with his AR saying that basically people were crazy for trying to advertise to youth. Now, we've seen in statistics what they actually categorize as youth, which isn't the more widely accepted. But can you go ahead and take us through Junior Sport Magazine?
Yeah, at Newsom's insistence, the legislature passed a law that basically bans marketing firearms or related activities to minors, to juniors, which obviously wipes out the Junior Shooting Sports program. Junior Shooting Sports Magazine could not publish in the state of California. So this is part of their war on gun culture. They want to commit culture side. They want to wipe out the gun culture by making it impossible to go to a gun store, to go to a gun show, to buy a gun, to have most guns, to do anything. And talking about guns or promoting guns through advertising or marketing is one of those things. So that's part of this law was part of that effort to just make it impossible, red tape the right to death, and make it impossible to promote it. We won in the Ninth Circuit in front of the three-judge panel. That was a great win. Said it's a violation of the First Amendment. And now the state is trying to get that case en banc, but we'll have to see what happens there. But in the meantime, we have a win, but there's still an injunction keeping that law in place for now, which we're fighting and trying to get lifted. So that all the ranges and CRPA and all these groups won't have to worry about getting sued if they publish something that promotes an event where junior shooters could participate.
Well, I guess being sued could be one thing, but existing at all is another. There was a sneaky effort. I won't call it concerted, but I will call it a sneaky effort. We did see in some legislation. This is SB 1327 from last year's legislative season. If you guys don't remember that one, that's where the California legislature basically came out and said, hey, I see that those guys over there in Texas are allowing people to bring lawsuits against abortion clinics. First of all, we think that's really bad, but second of all, we're going to replicate that legislation and do it to the firearms community over here. That has its own battle, but in the fine print of that law, they basically said that unless you win every argument in a lawsuit, you're not considered a prevailing party. So we came out with South Bay Rod and Gun Club v. Bonta. Can you go ahead and break this one down? Not just the lawsuit, but the importance of what prevailing parties mean, and how organizations like CRPA, like Gun Owners of California, really needed this to get struck down.
Yeah, when CRPA sues the government, we're representing we're a nonprofit corporation. We're not making money on the lawsuit. We're doing it on behalf of our members, advocating for a constitutional right. This is not like a lawsuit where somebody breaches a contract and doesn't pay me for the goods that I sold them, so that you would win by getting the money back. This is a lawsuit where we get declaratory relief. Typically, there aren't damages. Isn't a money component other than attorney's fees. If you are the prevailing party, that means if you win the lawsuit, you can make a claim for attorney's fees to be reimbursed to you from the government. So this is a critical part of our litigation plan. When we win, we want our money back. We want our attorneys. The CRPA wants its attorney's fees back. And what the 1327 would have done is make it so that you could never get those fees back. And not only that, but if you didn't win, you could be on the hook for the state's fees. Now that is about as unconstitutional as it gets. That's called driving people out of the right to the courts, to the judiciary. And so we couldn't really move forward with Duncan or Rhode or any of the other cases that we had until this issue was resolved, because people were afraid to get pulled into these to be plaintiffs in these cases because they might be on the hook. So we had to get those knocked out. We did that by making a motion in the Duncan and Rhode cases and a couple other cases in front of Judge Benitez saying, we need this resolved before we move forward with our other cases. And we wound up having, I believe it was like a 2-day hearing down there in front of Judge Benitez. Interestingly enough, we kind of put the California Attorney General in a box because they had submitted an amicus brief in Texas saying that this kind of situation, when it was set up this way for an abortion law, was unconstitutional. So they were making our argument against the law in the Texas abortion case, and then trying to argue the exact opposite thing here in California when it came to guns. It was the same legal principle, it's just guns versus abortion. So we moved to disqualify them. We pointed out that this is unethical. We told them that they can't take these inconsistent positions. They have to choose, what is this constitutional or not? They didn't want to take the position. We had to chase them to force them to the point where they were going to have to take a position. And finally, they said, we can't represent the state anymore on this. The Attorney General's office recuses itself. And when that happens, the governor either has to come in on his own or the case gets dismissed. So Governor Newsom then had to bring in his own personal lawyer to continue to try and defend the case. And he did an absolutely crappy job, which was not unexpected, considering all the arguments that the Attorney General had made in Texas, we were now using against him. And so that law was struck down, thankfully. So that is not in the way. That attorneys' fees shifting racket, that ploy that they came up with to try and kick us out of court and stop us from being able to challenge their unconstitutional laws, that has been knocked out, and we are now back in business on all the other lawsuits. And we got our attorneys' fees on that. We prevailed on that and got reimbursed for our fees on that one.
Yeah, and I've been telling people, obviously you can draw a conclusion on all of these laws, the constitutionality of them. But if you need the most blatant example of something that is a political ideology and the fact that they do not care about our constitutional rights, look no further than SB 1327, because you're right. They were projecting this idea as unconstitutional to somebody else, and then they blatantly turn it back around on the firearms community. I'm really glad, guys, that one is done. It is no longer in the courts. That was a victory, which is really good, because that stops a lot of unconstitutional processes taking place with future lawsuits. So how about another egregious one? You've got the handgun roster, which has existed in California for a while now. It's been challenged several times before, but post-Bruin, we saw the inception of Boland v. Bonta. We got a minor victory there, but it's still on track. Why don't you go ahead and break that one down?
Well, we got actually a fairly significant victory. We got a big win on. So the roster law requires handguns to be tested, drop tested, and torture tested, basically, to see if they misfire. But then that wasn't enough, so the legislature stacked on a requirement for a loaded chamber indicator, a magazine disconnect safety, and then microstamping. And when microstamping was added, none of the manufacturers could add that to any of their guns. Most people don't want a loaded chamber indicator or a magazine disconnect, because if you're down to one, if you don't have a magazine in your gun, you have one round, police hate it. People make the individual choice whether they want those safety features, but microstamping was something that it did nothing but bog up the gun and make it more expensive, and manufacturers refused to do it. Smith & Wesson and Ruger both announced they weren't not doing this. And so the number of guns that were on this roster of handguns that were approved for sale in California fell dramatically, down to like about 300 models. And that's nothing compared to tens of thousands of models that you can buy in other states. So we challenged that. We got a great ruling from the district court saying that all three of those things were unconstitutional to require those, and that was appealed. Now, interesting, when they appealed, the state did not appeal the microstamping ruling. So microstamping, that court ruling became final, and the microstamping requirement was struck down. As a result, there's been several new guns added to the roster that can be sold. They now have loaded chamber indicators and magazine disconnects, but they do not have microstamping. But I say several, there's like 4 new models. It's nothing it's a drop in the bucket compared to what you can get in every other state. And so now that's on appeal. It's been argued. We're waiting for an opinion from the Ninth Circuit. Now, interestingly enough, the state, never content, never, they'll never give up. This is all scorched earth. None of this stuff this is all a battle for America's soul, and the progressives will not let go. And neither will we, but it goes on forever. So they gave up on microstamping under the roster, but now they've passed a new microstamping law that goes into effect, I think not for a couple of years, I believe. And we'll be challenging that too. But in the meantime, it's not an issue in the current appeal. So we just have to get rid of the loaded chamber indicator and the magazine disconnect requirement, and then all these guns will come flooding back onto the available models that are available, the list of models that are available to buy in California. So that's a good one, and it's already showing some results in terms of some of the guns coming onto the roster.
Well, yeah, and I want to stick on that before I get to our final lawsuit here. Is there national precedent that kind of could be taken from that? I mean, you did see more legislation on microstamping in California. We've also see it in Illinois, New Jersey, New York. These proposed pieces of legislation are sort of popping up everywhere for microstamping. Is that lawsuit going to be referenced at all in future lawsuits for this microstamping? Where do you see that?
Of course, of course. I mean, all this is a national game. That's why CRPA is participating as amicus in other states in multiple cases. It's not just the cases that we're discussing that we have in California courts. CRPA recognizes these issues are now national. Look, what's going on here is the Everytown Law and the Bloomberg-funded lawyers that work there are pushing stuff in all the the purple or blue states where they think they can get away with it. They're pushing every law that they can possibly come up with. Anything they can cook up, they'll push on a willing legislator who wants to get his name in the paper and try and get it passed. And then they have to litigate it in all these other states. And CRPA participates in that litigation along with the Second Amendment Law Center as amicus rather than as the main plaintiff like it is in the California cases. So all of these cases, though, it's all a national game, and all of it is ultimately, as these issues settle out in the lower courts, it's going to wind up back in front of the Supreme Court again, I suspect. And that's why they're kind of trying to delay everything. They hope that this composition of the Supreme Court will change so they can get maybe some Biden appointees on there who won't respect the Second Amendment. So that's why it's a historic time for Second Amendment law. And anybody who supports the cause is a part of that history. So we're fighting as hard as we can. Unfortunately, money is the mother's milk of politics and litigation. So we count on contributions from members to help us keep all these cases rolling in court.
And then finally, I guess one of the more recent lawsuits that we have is the challenge against the LA County Sheriff with CCW wait times. Can you break that one open for us?
Put this in context. After Bruin came down, it got rid of the good cause requirement and required cities to issue any issuing agency, counties, cities, police departments, to issue CCWs for self-defense. So applications flooded in, people trying to get a CCW now that they could. And we educated, as part of the CRPA's CCW Reckoning Project, we educated cities and counties across the state on what their obligations now are and told them you need to start issuing CCWs, which most of them did. Even San Francisco has issued CCWs now. There are still lots of issues with how they evaluate candidates and things like that. But the big issue is how long it takes and then how much they charge. LA County was taking up to 1.5 years to process a CCW application. That is not constitutional. The state law requires a maximum of 120. We think that's probably not constitutional either, but it's better than 18 months. So and then Laverne was charging $1,000 just to apply for a CCW. So we sued the LA County and the city of Laverne over their delay and the prices that they're passing along to people. That's a recent lawsuit. We're filing our injunction request soon. Once again, we have strategic partners with Gun Owners of California, Gun Owners of America, Second Amendment Foundation on that one. And so, we need to break it down in LA County so that it becomes precedent throughout the rest of the state that cities have to process applications and they can't pass all the costs of processing an application onto the candidates. The state set up this licensing scheme, not us, not law-abiding citizens. So if you want a licensing scheme, you pay for it. Otherwise, go constitutional carry. So that lawsuit is very definitely a hot one for us, and it's in process.
So I guess, look, I mean, first of all, this is a lot of litigation. And to be quite frank, this isn't even the entire list. And aside from that, that's not all the litigation that's happening in California. But this is extensive, and this is a lot of movement. Looking into 2024, I've got a couple questions for you. I guess overall, What does your picture look like in 2024? And more specifically, we've talked in a couple of videos in the past, specifically on the volatility of the Ninth Circuit. The majority of these lawsuits are either in the Ninth Circuit now or are probably on their way there. Your sentiment from earlier in the year was that basically the Ninth Circuit had some reconciling to do. We've seen some unprecedented things. What does that make the picture look like in 2024?
I'm very hopeful, but a lot of this depends. I mean, the Ninth Circuit may try and play games, but the Ninth Circuit is no longer stacked the way it used to be. Thanks to the Trump administration, you've got some very, very pro Second Amendment judges, pro conservative judges on the court who see Bruen for what it is, follow Bruen faithfully, unlike some of the more progressive judges who want to twist Bruen like they twisted Heller to make it possible to uphold a lot of gun control laws. So I see the Ninth Circuit's going to have to come to terms with things. And if they don't come to terms the right way, whatever case they come down with first that gets it wrong is going to go right to SCOTUS. And I fully expect the Supreme Court will take it. In the meantime, there's multiple other cases in other circuit courts of appeal across the country that we're going to get some legal precedent opinions out of. And any of those could go to the Supreme Court. Illinois, for example, we're going to the Supreme Court on their semi-auto ban immediately. I'm working with the equivalent of CRPA, some groups like CRPA only in Illinois now. So again, it's a national game. The big thing that I'll be looking for in 2024, depending on whether or not and which case may get accepted by the Supreme Court, but the Supreme Court's already heard oral argument in the Rahimi case. And this whole methodology question, which is what drives the win or the loss, whether they get the Bruen methodology right or wrong. If they get it right, we typically win. If they get it wrong, they find a way to make us lose. So Rahimi may straighten out what the proper application of the Bruen methodology is. And if it does, then we take that right back and put that in front of the Ninth Circuit and say, you got to do it this way, as it now is as clear as a bell, and force them to not try and play games. So I'd say there's going to be circuit court opinions coming out from circuit courts across the country, 7th, 2nd, 9th, and there will be that Supreme Court decision out of Rahimi we'll see that at the end of June, most likely, although it might not take that long. And depending on how those come out, that will kind of probably define our Second Amendment rights for the foreseeable future. So, the stakes are pretty high here. And with all the millions, in fact, billions of dollars that Bloomberg is putting behind Everytown Law to try and water down the Second Amendment, to pull the Second Amendment's teeth, it's not a given. We have to fight. You can't mail this in. Every one of these things has to be hard fought, scorched earth, courtroom fights. And we give the generous nonprofit rates to CRPA, but even so, these things add up. It just takes so much time to do these briefs and try and head off all these games that some of these circuits try and play, where they twist Bruen. But we try and anticipate what they're going to say and say why they can't do it in advance. And then coordinating amicus briefs, that will continue to go on for the Second Amendment Law Center and CRPA and GOC. So that the game's afoot. I mean, history is in the making. And again, anybody who donates to the cause, you put $1 in this, you're part of history. And this is something that our children are going to live with under however it shakes out, and our children's children. I mean, it's a battle for America's soul. It's as simple as that, really. Is the progressive, woke, cancel culture, politically correct baloney that's being pushed by ultra progressives who want a big government nanny state. Is that going to be the way that America turns and how our future children and grandchildren live? Or are we going to stick with some of America's heritage that made us the greatest free country in the world to begin with? That's what's at stake.
There certainly is an awakening in the Second Amendment community. that nobody's going to fight the battles for us. I mean, this is why we see prominent people in the community like Armed Scholar and Reno May and Kim Rhode and others that are stepping up to be plaintiffs in these lawsuits. This is certainly a lot of litigation. We're going to continue and follow along. We're going to continue and fight as an organization to retain these rights, because as our founding fathers knew, it's necessary to keep our freedoms. Chuck, I want to thank you very much for going through all of this with us. Any final thoughts, any message to our faithful as we close out the year?
Keep the faith and don't give up hope. We are going to win. We just have to keep fighting. And ultimately, I firmly believe we will prevail here. The Constitution's on our side. And if you have faith, if the Lord's on our side, this is the way this country was designed to work. And so I know it's frustrating that it takes so long, but we're moving things along as fast as we can, and we just have to wait. We have to wait it out and fight it out in every jurisdiction that these battles present themselves, and then we'll ultimately win the war.
Well, absolutely, and I thank you again for being here. And if you like these videos, please, guys, it is helping. Let's work the algorithms. Be sure to like, share, and subscribe to these videos and this channel. It really helps get the message out to as many people as possible. And with that outreach, we can bring more people into this fight to secure its victory sooner rather than later. I want to thank you guys for another great year, all the comments that you've given us, all the suggestions. It's really helping us move along as a channel. I hope that you are at home celebrating in all of the ways that you can at this time of year, and we'll see you on the next one.